Hi, my name is Jamahl Kersey and I'm a criminal defense and immigration attorney at Kersey Law. In this video, I discuss the Fourth Amendment, the law which protects us from illegal searches and seizures. Under the Fourth Amendment to the Constitution, people have a right to be free from unreasonable searches and seizures. The Fourth Amendment requires officers to have a warrant prior to conducting a search. There are some exceptions to the warrant requirement, which we will discuss as well. Over the years, the United States Supreme Court has decided cases shaping our rules related to the Fourth Amendment. So we look to the case law to determine the reasonableness of a search. Essentially, a search only occurs if a person has a legitimate expectation of privacy in the place or the thing that the police officer searches. Whether someone has a legitimate expectation of privacy depends on two factors. One, does the person subjectively, in his own mind, expect that a place or thing is private? And two, is a person's subjective expectation objectively reasonable, meaning that society as a whole is willing to honor it? If the answers to both questions are yes, the police activity is considered a search. A judge would then determine whether the search is reasonable. A search warrant is an order signed by a judge that allows the police to search for particular items at a particular place and time. Officers obtain a warrant by providing a judge with information, usually a sworn statement based on what the officer or another witness observed. The judge must be satisfied there is probable cause in order to issue a warrant. Essentially, the officer has to identify objectively suspicious activity in order to establish probable cause. Once the officers have a warrant, they are permitted to search the areas indicated on the warrant. If officers conduct a search without a warrant, the search may be considered unreasonable, which may result in evidence being thrown out. Again, in order to conduct a search, a warrant is required unless an exception applies. A search conducted without a warrant may be justified if the person grants consent to a search. An officer may not have probable cause to conduct a search or make an arrest, but if the person is asked permission to search one's house or a car and the person says yes, then that would likely be considered a consent search and a warrant would not be required. An officer does not need a warrant to seize evidence that is in plain view where the officer has a right to be. If an officer pulls someone over for having a busted tail light and while the driver reaches for his registration, the officer notices a baggie of meth sitting in the center console in plain view, the officer would then be able to seize the baggie even though he did not have a warrant. On the other hand, if the officers unlawfully enter a home without a warrant and they see illegal drugs in plain view on a coffee table, they arguably would not be able to seize those drugs because they did not have the right to be in the home in the first place. Officers do not need a warrant to conduct a search incident to an arrest. So if they arrest a suspect, an officer has a right to protect himself by searching the suspect for weapons. They can also search for evidence that they believe the suspect might attempt to destroy. Cell phone searches are a hot button issue. So much personal information is stored in our phones, and the Supreme Court has ruled that we have a legitimate expectation of privacy with respect to the contents of our phones, and so officers must have a warrant to search them. But you must remember that if you grant consent to an officer to search your phone, you are waiving that right under the Fourth Amendment. Now, when police officers have information that gives them reasonable suspicion that a person has committed a crime, officers can briefly detain that person for a brief investigation that would be less than an arrest or a complete search. And if they have reason to believe that the detained person might be armed and dangerous, they can conduct a limited pat-down to check for concealed weapons. This is called the stop and frisk rule. A warrant is not required in this situation. Cars present a unique set of issues because of their mobility and the risks involved during traffic stops. An officer is permitted to order a driver out of the vehicle during a traffic stop. If an officer reasonably believes that the driver or passengers might be carrying weapons, they can conduct a short pat-down. However, the officers cannot search the car without a warrant unless he has reason to believe that the car has a weapon or other evidence of crime that someone other than the driver might be able to dispose of. If a driver is arrested for DUI or reckless driving and then the car is towed and impounded, the officer can conduct an inventory search of the vehicle. The search is for the protection of the lot and the people at the lot, and also to protect against claims that items were stolen from the car. There are emergency situations in which the preservation of evidence or public safety concerns allow officers to conduct searches without a warrant. An example of such an emergency situation would be an officer chasing an armed robbery suspect who then makes it inside his apartment. The officer would be able to enter the home without a warrant and search the suspect. So what happens when items are seized in violation of the Fourth Amendment? Under the exclusionary rule, items seized in violation of the Fourth Amendment cannot be used as evidence against a defendant in a criminal case. The argument in support of the exclusionary rule is, if illegally seized evidence is not admissible in court, then officers will be less likely to conduct illegal searches and seizures. A defense attorney challenges an illegal search or seizure by filing a motion to suppress evidence. The argument is generally that the police did not have a warrant to search and no exceptions to the warrant requirement apply, and so therefore any evidence seized should be excluded. The prosecutor has the opportunity to file a reply as to why the evidence should not be excluded. There is then a court hearing where the officers who conducted the search or seizure are questioned under oath. The judge then issues a decision as to whether the evidence in question will be excluded. The search and seizure laws are pretty complex. In law school, these topics are the basis of a full semester course, but hopefully you now have a better understanding of the Fourth Amendment and how it's applied. Stay tuned for more useful information in our Criminal Law 101 series. Don't forget to like and share on Facebook and hit the subscribe button on YouTube. Thanks so much for watching. Till next time.